Good afternoon, everyone. As Mark stated, I'm Marilyn Nash, the Interim Assistant Regional Director, Regional Outreach Officer here at the United States Patent and Trademark Office. And I work out of the Office of Public Engagement. And so, in my role here out of the Midwest, Elijah J. McCoy, Midwest Regional Office, which is located in Detroit, we serve as an extension of our headquarters, which is based in Alexandria, Virginia. And what I'm here to do today, as I do in most of my role, is to share resources with you on how to identify and protect your intellectual property. With our time here today, I'll be on for about 45 minutes. I don't want to make this a dull, like death by PowerPoint. I really want this to be interactive. What I'll be presenting today is information on patents, trademarks, copyrights, and trade secrets. But I would love for you to join in, pop your questions in the chat. I'll be taking a peek at my slides, taking a peek at the chat so that I can incorporate those, right? The worst thing is to have a question and you wait to the very end and you're like, hey, I forgot my question. So go ahead and feel free to pop those questions in the chat and I'll share some information. But let's go ahead and get started as I give you this overview. Let's see if I can advance here. So, intellectual property basics and helpful resources today. I do want to give a disclaimer that this should not be construed as legal advice. It is for informational purposes only. We always advise that you speak with a legal practitioner, whether that be an IP attorney or a patent agent regarding these matters. So, as I mentioned, I'll cover an overview of intellectual property, provide some resources. But before we get started, I'll talk a little bit about what is the USPTO. So, the USPTO, United States Patent and Trademark Office, is one of 12 bureaus within the Department of Commerce that work to create conditions for economic growth and opportunity for all communities. So, the USPTO was established in 1790 as the federal agency that grants patents and registers trademarks. And so our mission is to drive U.S. innovation and global competitiveness for the benefit of all Americans. As I mentioned here, Midwest Elijah J. McCoy Regional Outreach Office located here in Detroit. This is where I am currently located. The Midwest office, as we say for short, is the first office, the Regional Outreach Office opened outside of headquarters. And again, our role is to connect filers and promote innovation, assist inventors and filers with their patent and trademark applications. We also do exactly what I'm doing today is reaching out to the public, sharing those resources, providing programming so that you become more informed again about how to identify and protect your intellectual property. So if you were here with me a little closer geographically, you'd be able to come right on into the office. But if not, virtual is a wonderful thing because you can connect with me by setting up a stakeholder meeting, emailing. I am here as well as my counterparts to be responsive to you. Across our region, our 9 state region, which as you see here includes Michigan, Minnesota, Ohio, West Virginia, Wisconsin, Illinois, Indiana, Iowa, and Kentucky. Across those 9 states, we also have 19 patent and trademark resource centers, which are a nationwide network of academic, public, and state libraries that have librarians there who are very experienced and can assist you with trademark and patent assistance as well. Typically, you would go to a PTRC either for training or as part of your filing process, that comprehensive search process. So next, let's talk a little bit about the overview of intellectual property. So what is IP? It is creations of the mind, and it sort of encompasses this inventions, literary and artistic works, designs, symbols, names, and images used in commerce. And ownership or protection of intellectual property allows the owner to exclude others from using your inventions, literary works, designs, or your images used in commerce. Right? So those 4 types that I mentioned earlier: patents, trademarks, copyrights, and trade secrets. So just to give a bit of an overview to talk a little bit about different types, because I do get those questions. Can I patent my trademark? Can I trademark my copyright, right? So today I just kind of want to demystify that, right? Trying to create some separation and definition around those four types. So patents typically include those technical inventions such as chemical compositions like pharmaceutical drugs, mechanical processes, like think machinery, machine designs that are new, unique, and usable, right? So they have to have function. You must be able to disclose how they function, right? So that patent protection safeguards inventions and processes from other parties copying, making, using, selling your invention without the inventor's consent. And then as we turn to trademarks, which is a word, a phrase, a design, a combination, and I'll get into some other lesser known trademark types that identifies your goods, right? It distinguishes them from the goods or services of others, and it really indicates the source of your goods or services. So federal registration of your trademark protects the trademark from being registered by someone else without permission, and it helps prevent others from using a trademark that is similar to yours, what we call creating a likelihood of confusion. So when we look at copyrights, copyrights are those artistic works, literary works, intellectually created works, whether it be music, novels, software code, photographs, paintings, anything that's in a tangible medium, a fixed medium, meaning it can be reproduced. So federal registration protects those rights as well from others reproducing, distributing, performing, or displaying your creative work for profit. And then trade secrets is just what it sounds like. It's any information that derives value from being kept secret. So for that trade secret, there's no federal registration process, but there are safeguards such as non disclosure agreements, digital encryption, or some sort of physical security that can be put in place to maintain confidentiality. So I'll talk a bit about patents here. And um, patents is one of those like sort of in-depth topics. And typically I find amongst small business owners, there's more likely to be trade secrets or trademarks that are more useful. So I am going to skim through this information, but again, stop me where you need to. I'll just check the chat to make sure that I'm tracking any inquiries that may come up about patents. So, again, a patent. As a U.S. patent, you, the inventor, will have the right to exclude others from making, using, selling, offering for sale, or even importing your invention into the U.S. It should be noted that patent protection is territorial, meaning if you file for patent protection here in the U.S., it is only protected here in the U.S. Again, prevents others from profiting from your invention within the US or importing your invention into the US. So if you did want to receive a patent, say for Japan or Europe or Canada, you must file with those countries, right? There's no worldwide patent. Now, a patent does have a limited term, and depending on the type of patent, that term is either 15 or 20 years. So there are three types: utility, design, and plant patents. And the utility is for inventing a new or improved useful process, machine, article of manufacture, or composition of matter. Design patents are for inventing new, original, and ornamental design for an article of manufacture. And you'll see there, those are the two differences. A utility patent has 20 years of patent protection. A design has 15 years of patent protection. And then there is also a plant patent for inventing and discovering asexually reproducing distinctly new and different varieties of plants. So that plant patent has a term of 20 years. So what is eligible for protection? So you'll see a list here on the left and then a list on the right. So keeping in mind a patent to be issued, your invention must meet four conditions. It must be able to be used, right? It cannot just be theory. It must have a clear description of how to make and use the invention, and that is what you would disclose in your patent application. It must be new or novel, meaning something not done before. and not obvious as it relates to a change to something already invented, right? So patent laws define what the limits of, that can be patented. So again, laws of nature, physical phenomenon, abstract ideas cannot be patented, nor can an idea or merely a suggestion. Why? Because you must be able to describe how to make it, how to use it, and it must be able to be used. So, when you're filing for patent protection, there are two types. And if you all have ever attempted to file a patent, you may have heard the term provisional and non provisional. So, for a utility patent application, you do have the choice of provisional or non provisional. The provisional patent is preferred if you are not quite sure if you're ready to go full steam ahead with your patent. It does allow you to establish a filing date. So when you submit your filing application, the USPTO will receive it. There will be a letter stating that it's been received, and it will give you that filing date. And that filing date is going to be critical because if someone else says, hey, 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 wait, that was my invention, you have the proof that you have filed first. I do want to note that the US is a first to file country. So having that filing date is, again, going to be important for who has filed first, not who has invented first. A provisional patent application also does not require claims, which are your more extensive, not too narrow, not too broad description of what you're claiming for patent protection. And it is less expensive to file the provisional application as opposed to all of the fees that come with a non provisional. I do want to note that a provisional patent application is not published and it is not examined. So just filing the provisional application alone will not lead to an actual patent. But again, it's establishing your filing date. It is establishing 12 months of patent pending protection. Perhaps you want to enter into what I want to say. It's not a pitch competition. Perhaps you want to enter into a pitch competition. Maybe it's something that you want to start to publish information on your website, or you anticipate public disclosure. So that provisional patent application puts some safeguards in place that will allow you to start to have those conversations, have those public disclosures while still having that patent protection. You don't have to file a provisional to file the non-provisional, but if you do decide that you want to move forward and file that non-provisional, you can claim that filing date of the provisional as long as the claims that you've drafted within a non-provisional are included into that non-provisional application. Those statutory requirements, those four that I mentioned, being new and novel, being usable, you must be able to describe them, being non-obvious, that has to be proven. Again, it is more expensive, and so you'll look at those fees that are required to submit. This application is published, meaning it will be made public. So keeping in mind anything that you disclosed, your claims, your drawings, how it works is made public in exchange for patent protection. And this is the application that is examined by our patent examiners. So this can result in a patent. And I do say can. Not every patent application results in a patent. They may find that there is already an invention very similar or the same already out there. Um, it may not meet those statutory requirements. Again, that patent law, if it doesn't fall in that patent law, so it can result in a patent. During the examination process, the examiner and either the applicant, whether you're a pro se applicant, if you file without an attorney, or the examiner and the attorney will have some conversations, some correspondence regarding the patent along that examination process. That again, that could lead to that. And I should note that most patent applications, it's not a one and done, right? Just when you file it, it examines. If it meets those requirements, it results in a patent. You are looking at a timeline of 24 to 36 months for most patents. And so it is something that you want to consider as part of your business planning. So benefits of a patent, should you decide to file, right? you have those exclusive rights to your invention for that limited term, either 15 or 20 years. This gives you the ability to assert and enforce your rights against infringement. Again, someone trying to make, use, or sell your invention or importing your invention into the US. It can create possible streams of revenue through sales, or should you decide to license your invention, right? It can generate those streams. It's attractive to lenders and investors to obtain funding. We often speak of Shark Tank. If many of you have seen that, they will ask, is this patented or do you have a patent pending, right? They want to know, can they leverage that exclusivity for that limited term, for competitiveness in the market, right? And that is often attractive, in order to obtain that funding. And then again, having that competitive advantage in the marketplace. You have that patented, limited, exclusive invention that no one else can claim. And then it may increase your business asset portfolio. So if you are a small business, perhaps looking to make yourself attractive to those larger businesses for a merger or an acquisition. And of course, it promotes innovation and economic growth. You disclosing your patent in exchange for the patent protection would allow another inventor to come and look, or take a look at your invention and say, I'd like to improve upon that. Perhaps I'd like to collaborate that. So, in the greater scheme of things, it is promoting and advancing innovation. I do want to note that USPTO is not an enforcement agency. We protect the patents, right? We register trademarks and we grant patents, but we are not enforcement agency. So, in order to enforce your patent, the onus is on the owner, and it can be done by monitoring the marketplace for infringing products and taking the appropriate measures for infringement. And so, some of the resources that I'll share, and I will include them a little bit later, are stopfakes.gov, which provides information and guidance for both industry and country of interest. And then Customs and Border Protection, CBP, can provide patent protection and enforcement. If you, as the owner, file an exclusion order through the International Trade Commission, you can then take that exclusion order, and Customs and Border Patrol can again stop that importation of your invention into the US. Let me just do a check here in the chat. So Naomi asked, what happens after the 12-month mark for a provisional application if you don't file by the date? That's a great question, Naomi. So if you don't file the non-provisional application, your provisional essentially will be considered abandoned. You do want to think about, and abandonment is okay, right? Abandonment within that 12-month mark, and it is a strict 12-month mark. There are no extensions. If within that 12 months you say, you know what, I've done the research, it may be too costly, perhaps the technology that, it's not ready to come to market. There could be any number of reasons why you decide not to pursue or to continue to pursue patent application, but you should know that that provisional will just be considered abandoned. Again, if you want to file that non-provisional application within that 12-month mark, the protections that you established in the provisional, the claims, your invention, you can carry that over and carry over that filing date as well. And then Mark asked, what is the current time frame for trademark review? Trademark review is a little bit of a shorter time frame, and I believe about 18 months. And I should state that right now the USPTO is doing a remarkable job of hiring new patent examiners, new trademark attorneys to reduce this examination time frame. So hopefully we'll see that decrease in the next several months here.
Awesome.
Great. So for trade secrets, what is that trade secret, right? So again, anything that derives value from not being known, your proprietary information. It could be formulas, business information, methods that give you that competitive advantage. Again, there is no formal or federal filing or registration process for that. So again, on the owner to protect protect it with your life, protect your business with your life, right? To keep that confidentiality. So examples here, some fun examples. I think we recognize a lot of the brands that we see here. They're operating with trade secrets, successfully operating, I might ask, right? So the Google here algorithm, a search algorithm, as I mentioned, software could be copywritten. In the case this is not. The Google search algorithm is a trade secret, so it has not been publicly disclosed. I have no clue how I can type the first three letters and it will read my entire mind and come up just with what I'm looking for, but that is a trade secret. So is the KFC recipe. Of course, the classic Coca Cola recipe. No one has cracked that trade secret yet. The oh, sorry, was I muted for some time?
Just a second or two. You're good.
I'm back. Okay.
Yep.
Sorry about that. So WD-40, that formulation is a trade secret. And then the New York Times bestsellers list. So they keep that a trade secret on how they rank and nominate those number one bestseller. That is a trade secret. So you in fact may have that, whether it's your marketing strategy. How are you so efficient and effective at reaching your audience, right? Your list of client or vendors, that can be considered a trade secret. And then any combination of your methods, your techniques, or your processes. So trade secrets are useful because um, if you have a product or process that doesn't meet patentability criteria, if you haven't already publicly disclosed your patent through an application, through discussing it, like I said, through a pitch competition or widely publicizing it, right? So think business strategy. You want to come to market. What are some of the things that you should be considering? Do you want to protect with patent? If it doesn't meet patentability criteria, should you consider trade secrets? This may be part of your own business development strategy. So, again, trade secrets can be useful when your product or process doesn't meet that patentability criteria. There's no set term for protection. So, while a patent is exclusively yours for that 15 to 20 years, as long as you can successfully keep that trade secret under wraps, there's no set term for protection. Again, think of that classic case of Coca Cola. We're talking generations now as a trade secret, right? And then there are no filing fees or registration fees, whereas with patents, you have your initial fees, then you have maintenance fees periodically, as you do with trademarks. So there are no filing fees, but again, there may still be some investment required to maintain your trade secret, which could include security measures, non disclosure agreements, some legal fees, and the like. So, some things to think about there. And then how could you lose a trade secret? I think understanding how you could lose it is helpful to understand how can you protect it. So fair to take adequate steps for disclosure. So cybersecurity, right? If you have it on one single system or you have it on a web-based system, an unsecure site, and someone hacks your site, you're vulnerable, right? You could possibly lose your trade secret if you've placed that proprietary data online in some way, right? If you have some physical component under lock and key, if you lose the lock or someone picks the lock, like literally, trade secret is gone if you've written down a recipe or such, right? If you have a lack of non disclosure agreements, right? If you have a business partner or you have contracted with a vendor to create something for you and you haven't explicitly stated that they cannot repeat this information, duplicate this information, and they go out and blab to the world about what they're working on or how they're helping you to bring something to market, those non compete agreements or any written policies. You do want to explore having those in place before you start having those sensitive discussions, right? That owner or owner authorized disclosure, we've seen it. You're working with a business partner, particularly with family business partners, and you have a fallout. What happens? One member goes this way, another member goes this way, discussions, someone spills the beans, right? Again, we talked about data breaches, reverse engineering, right? Someone could just buy your invention or work through your process and they work to kind of hack or like break the code of that. And then independent development. It is entirely possible that someone on the other side of the world that you've never met, you know nothing about, they haven't sought anything out about you, develops something similar, right? So you do just want to think about ways that you could lose your trade secret and then sort of work backwards to protect it. So I do see a question in the chat. With trade secrets, does that mean you no longer have to disclose your ingredients on an item label? Well, with your trade secrets, the proprietary data may be not only a special ingredient, it may be the blend of ingredients. So I have to be careful there because if it is like a food item or a cosmetic item, you may be required to still disclose those agreements. I have seen though for certain oils or something where they say proprietary blend of oils, that may be sufficient, but I would urge you to check with your state regulations, and then if it is subject to like FDA or USDA, to ensure that you're also meeting the requirements for that. So with the trade secrets, again, you're not disclosing how you make it, your exact formulation, but again, you still may be required to disclose the ingredients, maybe just not the exact amount.
Okay.
And then Ryan asks, for trade secrets that are formed from a combination of existing methods, techniques, how distinct do they need to be from the previous techniques before you can claim it as your own? So that's an interesting one, Ryan, right? If there's one trade secret and then you create another trade secret that builds on another trade secret, how would you know? How would someone know? How would your competitors know? And I don't ask that in jest, but I guess it would have to be sort of called into question, um, to say, well, prove your trade secret, and the other party prove your trade secret. I'm not quite sure, is at least not coming to mind where you would have to do so. So I think, again, in keeping your information confidential, and operating uh, with that trade secret as confidential information. Now, what we may encounter, and I'll be talking about that next, particularly with trademarks, right? Say there's a formulation, say there's like, let's use KFC, right? Because they have these secret herbs and recipes. And then you also have maybe your own Ryan's chicken and this formulation. And someone says, this tastes very similar to KFC. Are you sure you haven't figured out the secret? You say, no, this is Ryan's secret sauce. Trademark may add that level of protection that then allows myself as a consumer to distinguish KFC from Ryan's by looking at the brand. I want to seek out Ryan's chicken and secret sauce versus KFC. So IP is not a, I only have a patent or only have a trademark. Sometimes you have to layer that protection in order to distinguish yourself, create that competitive advantage. So Ryan, I hope that helps. So let's go ahead and jump into trademarks. So what is a trademark? It is that intellectual property right that allows the owner to control the use of a mark, right? It is an indicator of source, like a brand name, a slogan, or even a logo. So we see here, right, you have Apple for computers and mobile devices, AA for insurance service provider, Dodge for vehicles, etc. Again, I mentioned that there are some trademarks that are not so common, including a shape, a sound, or a smell, right? Certainly, we have seen those words and those symbols, those names, and even colors, right? And again, a trademark indicates the source of a product or service, and it provides legal protection for a brand. So I do want to note that a trademark is not a business license, right? And when you create your website, your web domain name at www.brandname.com, that is not your trademark. You do want to check with your state and local regulations for requirements for your business formation and operation. Um, again, just because you submit that trademark application, your business license process is separate. And I just want to make that distinction because I've had those conversations, right? Or conversely, oh, I have my web name, I have my brand name, I can go trademark, right? Well, maybe. If you haven't conducted a comprehensive trademark search, there is a great possibility that there is someone somewhere else with a federally registered trademark or a common law trademark that could create likelihood of confusion. I know that there have been cases, and they are quite unfortunate, when a business develops their full brand. They have their name, they have their logo, they have their products, they've started selling. You maybe you're into year two, you're into year three, but then at some point along your business timeline, someone says, hey, you're infringing upon my trademark. I filed, I'm using this in this way. You haven't filed registration, and then there's that trademark infringement. So we do want to help you avoid that by, again, and I have to be careful here, not business advice, but consideration that if you are forming a business, take a look at your brand, search for that brand prior to setting up your domain name, filing your business name with the state if you intend to use that name to indicate your source of goods, right? You don't want to get too far along the line and you encounter this infringement. So some examples of trademarks, again, trademarks can be words, trademarks can be designs. As you see, Starbucks, Nike, and Target on the left, they convey or help us identify the source of goods just as their logo does, right? If we see those words standalone, we know Starbucks is coffee, Nike is sports apparel, Target is large retailer. If we saw those designs or those logos as standalone, we could also identify that source of goods. Hey, there's a Starbucks coffee right up the street, and hey, I've got on a Nike jumpsuit, and of course Target for all my weekend shopping. Right. So again, some additional examples of trademarks: product packaging, product design, trade dress can also be those sort of uncommon types that sound, smell, color. So to give you an example of sound, like the MGM Lion Roar is actually a trademark, right? The color shades as we see there, the UPS brown and yellow, or the John Deere green and yellow. Smells, Play-Doh actually has a trademark on that sort of vanilla musk smell. Um, and the unique aroma used in Verizon stores, that is also trademarked. So think, as far as your business, your product, or anything that you're developing, what is distinctively and uniquely yours that may require that IP protection so that you distinguish yourself from your competitors, right? Now, what does a trademark not do? It does not mean that you legally own a word or phrase. So I like to use the example, the word Delta, right? I could say Delta, Delta, Delta. Delta may bring to mind either a dental company, it could bring to mind the airline service, it could even bring to mind faucets, right? If you're doing some interior decorating. So that word Delta is not owned by any one of those companies. However, they have used it in a way to identify, source, and distinguish themselves from their competitors, right? It doesn't mean you can stop people from using a word or phrase, right? There, no one's going to charge me every time I use that or just simply say that name. It's only if I were to use it in connection with my goods or services for which I have no right to do, that then it becomes a problem, right? And you certainly can't just collect money because someone used a word or phrase. Again, they would have to be using it to identify the source of a goods or service for profit before it becomes problematic, right? Common law trademarks. So a trademark that is used in commerce in connection with specific goods or services, but is not yet registered, is subject to common law rights, right? Rights would be limited to a geographic area. So, say you're currently operating within your community or within your city, sort of locally. You can use the TM to distinguish yourself, and Your customers get to know you. Perhaps you're selling at fairs or in local stores, right? And you have that trademark, and they know, hey, that's Maryland's, tea, and I want Maryland's tea. I could use that symbol, TM, if I were producing a service, if I was providing a service, a unique service that I want people to know. I could use that SM for service mark, but I could not use that encircled R until I complete federal registration, right? That means filing for that trademark, filing that trademark application. So in theory, you could continue to use that TM symbol and exercise common law trademark rights as long as you are using it in connection with your goods or services. Now, some considerations, if you are selling online, right, and you start to get a customer, you're in Minnesota, someone purchases your goods and services in Michigan, it's popping up, Ohio, you're in the Midwest, maybe California or Florida, you may want to consider federal registration, right? One is you're starting to cross state lines, that gets into the federal jurisdiction. And someone in Florida could say, hey, I'm also using Maryland's tea as a trademark, right? And I filed federal registration. And I can show you that I've been using this in connection with my goods and services. They may be able to, be the winner for their infringement suit. If I've only used it locally, I haven't protected it federally, and someone who has protected it federally um, finds out that I'm using it, right? Unbeknownst to me, I didn't know someone in Florida was using Maryland's tea as a trademark. So that is why you do want to do that comprehensive search before you start doing business, especially before you start selling in that federal jurisdiction space across state lines, right? And then keep in mind, U.S. is a first to use country for trademarks. For patents, I mentioned first to file. For trademarks, first to use. So if you're using it in commerce, when you have that first sale, you want to keep those receipts, keep your documentation. If someone says, hey, I'm using this and I filed, we're going to be looking for who has used that trademark in connection with a good or service in commerce first.
I have a quick question in the chat, Marilyn. Has to do
Sure.
with the cannabis industry. Is there any difference in the cannabis industry with trademarks?
Sure. So, how does trademarks work in the cannabis industry? So, cannabis is a little bit tricky for us because cannabis, of course, is legal in certain states, but it is not legal federally. So, as of this time, there isn't intellectual property protection for those items that are not federally legal.
Interesting. Okay.
hmm I know that we probably often see those names and logos, and they're real catchy, and they're very similar to other goods and services. But again, there is not guidance there because of the legalities. But that's a great
Okay.
question. I actually
Okay.
thought the same thing when I started working for the PTO. So, yeah, that's a great question. And, oh, you know what, I think I went a little fast there. I wanted to talk a little bit about the federal registration rights, right? Because I was talking about common law for trademarks. So, again, federal registration for a trademark at the USPTO is not required, but it does bring several benefits, right? Number one is what I just spoke of, that nationwide protection. You can file an intent to use application at the USPTO. However, again, you'll need to use that mark in actual commerce to register it. So, again, if you are forming your business, you're standing your business up, you intend to use this trademark, you can file that intent to use, kind of putting us on notice federally, hey, I intend to file for my federal registration once I start using my goods and commerce and goods and services in commerce, right? So you can't though just think of a great name or logo for a product and just own it forever without actually using it. The protection is only enforceable if you're selling your goods, right? Of course, you're able to use that encircled R. Once you have received federal registration, you can bring legal action concerning your trademark to federal court to stop those infringers. You can bar the federal registration or prevent someone else um, from registering a trademark that is likely to cause confusion. So again, I use the example Maryland's tea. I could have been speaking of t-shirts. I could have been speaking of tea, hot tea to drink. If someone wanted to register Maryland's tea, but say, hey, I'm using it for soda, or I'm using it for like a carbonated tea or matcha tea or something. If I have that federal registration, I can say, hey, it may be different, or Maryland's t-shirts. That's going to create confusion to consumers. If I have Maryland's tea for hot tea over here and you indicate that you want to do Maryland's tea for matcha tea, I've already registered this, I've already protected it under this class. That would create likelihood of confusion. I can stop that, right? And then federal registration for trademark can last forever, but again, continuous use and commerce, goods and services, right? And then of course you have to file those post-registration and maintenance documents at the required intervals.
Okay. Katie has a question here. Would it be separate trademarks for a business name and logo, or can they be combined into one trademark?
Great question, Katie. So with trademarks, we can see a few ways. Your business name, if you're going to use it in connection with a goods or service, as I showed on that previous slide, Starbucks, the word alone can be trademarked, or that logo. I have seen, and I'll use the famous Nike, right? They have the swoosh is trademarked, the word Nike is trademarked, the swoosh with the just do it is trademarked. So they can be combined. It is not required. And so you would want to think about how you want to represent yourself in the marketplace. Is it that you perhaps sometimes want to be able to use that logo on a label alone and have a consumer recognize that as the source for your good or service? Or do you always intend to use the name and logo together? Or do you
Hmm.
simply just want your business name to have that same recognition without your logo? So it's more about how you want to present yourself in the marketplace to help drive that decision on how you trademark. But again, Nike and Apple and several other like large companies, you'll see they have several trademarks, and then they're able to use them according to whichever class they filed for, and use those in combination or separate.
Katie likes the response. I agree. Yes.
Okay, good, Katie. I'm glad that was helpful. So I want to be mindful. I do see that we have roughly 20, well, maybe about 15 minutes or so left. I'm
Yes.
glad the questions are coming in the chat so that I can stop and answer those along the way. I have copyrights and then a few helpful resources. So I'm mindful of that and I'll get through those. So, copyright. So it should be noted, right? You talk about copyrights. I said I'm U.S. Patent and Trademark Office. We do work closely with the U.S. Copyright Office, which is a part of the Library of Congress, to advise on intellectual property before Congress and to the president. So USCO, U.S. Copyright Office, administers the registration for copyrights, which is that original work, those original works, be it film, and I'll show a few instances on the next page there, and a fixed work, original work in a tangible medium. So one that can be communicated, reproduced, or perceived at a later time. So what you put on your website is copyrightable. If you produce a YouTube video, if you've produced a painting, if you've taken a photograph, um, if you wrote a poem in your notebook some time ago, even if you were 10 years old, that is copyright material. So lots of us are owners of copyright and we don't even know it. We're always producing these original works. You can use that C without federal registration, right? To show that you are the originator, the author of those works. So again, we look for music, books, movies, artwork, television shows. However, there's also choreography, architecture, software, compilations of information that could also fall under copyright protection, right? So the rights for a copyright owner, um, you're able to reproduce your work, prepare derivative works, sell or lease or lend copies of your works. If you are like a choreographer, filmmaker, right, an artist, a music artist, you've written music, publicly perform that work, and you can also authorize others to exercise your exclusive rights, essentially licensing your copyright material, right? Helpful things to know: copyright protection is automatic at the time your work is created. So again, you're a business owner and you want to talk about your business or your invention on your website. That material is copywritten. Perhaps you've done some research, your own research, right? Not borrowed from someone else, and you want to produce your findings, and you place that in a white paper and it's published somewhere. But the moment that you put it down on a medium where it could be reproduced, that copyright is created, and that protection can be enhanced though through registration, right? So registration is necessary to enforce those exclusive rights should you need to take it to federal court. The U.S. Copyright Office will issue a certificate of registration to publicly show authorship and ownership to the public. And registration of a copyright can be made at any time within the life of the copyright. So, for the terms of the copyright, it is, let me look at my notes here, it is the lifetime of the author plus 70 years, I believe. If it is a synonymous work, it is the lifetime of the author plus 100 years. So I will have to verify that with the U.S. Copyright Office, but essentially it is the lifetime of the author plus, right? So if it's something that you want to um, transfer your IP rights perhaps to family or to a business partner, you can do that. Additional benefits of registration, again, needed before you can have that infringement suit. It establishes that evidence of a valid copyright and facts, and like trademarks and like patents, you would establish a record with the Customs and Border Protection for enforcement purposes. Right. So again, we've covered the 4 different types of intellectual property. So I hope you have a better understanding of what patent protection will protect those new and inventive ideas, trademark protecting the source of your goods and services, the images used with those goods and services, copyright as a creative expression stored in a tangible medium, and then those trade secrets, which is that valuable confidential information that you're building your business on. So I do appreciate, I think it's been Mark and Maddie adding resources into the chat.
Yeah.
Great. I
Sorry.
appreciate that. Thank you. No, that works. Have a few resources. Perhaps it's been shared. I couldn't quite keep track of the resources there, but one great place to start is our IP identifier tool. This tool will take you to a site here at the uspto.gov, and you can answer a few questions. There's a basic version and an advanced version. Your basic version essentially helps you to start to sort of again flesh out, should I be going for patent protection, trademark, copyright protection, and then there's a path of resources that come along with how to file. The same for advanced. Perhaps you already know you want to file for that trademark protection, and so it will lead you down that path of what to do next. So great place to start. For patent resources, if you want to dig a little deeper behind what's behind that patent application, landing here at our uspto.gov/patents, particularly the patent basics and that patent step process step by step. It is a comprehensive list of what to do, whether you need to file for utility design or plant patent, Should you choose to file for a provisional versus non-provisional, it will take you to those fees, additional guidance, helpful resources are there. We have a similar page for trademark resources. So again, sort of this timeline of process and application will give you a better sort of behind the curtains look at that application process. For copyright resources, again, I would send you over to the U.S. Copyright Office. I've been over to this site, copyright.gov, plenty of easy to follow resources to
Mm-hmm.
help you
Yeah.
understand what is a copyright and how to file, right? And things that you can do. A lot of questions that I get, fair use, right? Marilyn, if I want to use this other author's work as part of my work, how do I do that, right? So those fair use rights are labeled there, are listed there. And then training some programs. So the USPTO has a number of in-person and virtual events that are still ongoing for now, right? Including our Path to Patent and our Trademark Basics Bootcamp. Both of those are free 8-week series that breaks down each part of the patent application, each part of the trademark application, including common mistakes to avoid. So you can jump on those at any time. You don't have to start at session one. They run right now every quarter. They refresh every quarter. So take a look on our site. And again, you may find another free event that piques your interest. USPTO in your region. Perhaps you're outside of Minnesota or outside of the Midwest region. You're in a neighboring state joining us today. The USPTO, in addition to the Midwest Region Office, we have 4 other regional offices, as well as I mentioned those PTRCs, which are extremely helpful in getting you connected to various resources and technical assistance. And then if you're looking for something else, legal assistance or pro bono program, we have both a patent pro bono program, which is more well known. There are resources for a trademark pro bono program that's listed. If you need help finding an attorney that's registered to present before the USPTO or patent attorney, there are law schools, right? So there are law schools around the nation who will also assist filers with the preparation of their patent or trademark application. Pro se, I mentioned that earlier. If you are filing without an attorney, there is pro se assistance for patent filers. And so those are experts that you can reach by phone, which is good to talk to someone and understand perhaps you're stuck on a part of the application or part of the filing process. And then if you're looking for protection abroad, as you're developing your business strategy, if you've already identified perhaps once you get U.S. protection here in the U.S., perhaps you want to go abroad, or if you, as part of your bringing your product to market, you have an outside manufacturer, a foreign manufacturer. I do encourage you to look at how do you protect your intellectual property abroad anytime that you are bringing in those global partnerships. And couple things left. Our Inventors newsletter. So this is a great resource, a monthly newsletter to find out what's happening around the USPTO, updates. I know we just rolled out some new tools for searching. You can find information there, as well as additional resources on how to protect and grow your business. We do often feature programs with other federal agencies. We collaborate with other organizations to bring you more insight on IP protection and identification. So I encourage you to take a look at that. And then the last piece, if you are looking to say, hey, Marilyn, I have a question and I forgot to ask it on today's webinar.
Yeah.
Right? Or I wasn't quite ready at the time that you spoke, but now I am. Can you assist me? We certainly can. You can email directly to midwest@uspto.gov, or you can call. Our wonderful office manager will either direct you to me or direct you to an expert, right? Maybe there's some other department that you need to speak to, but we will get you connected. So I will stop sharing for now.
That
And
is fantastic. There is one more question in
is
there if you
there
wanted
in
to take a
there?
quick peek. Yep.
Okay. Is this how much protection do I have by filing a notice of intent to apply for a trademark with the USPTO and renewing it until I'm ready to begin using the trademark? Well, protection, I'm going to say that sort of in quotes.
Yeah.
As long as you in right, so that intent to use is really telling the USPTO that I am bringing a product or service to the market. And essentially, I like to reserve my trademark when I do bring it to the market, but this won't go on perpetually. These notices are reviewed, and I don't quite see the formal filing trademark application, or there may be follow up to say, have you already sold or began to use your goods or service in commerce? If you have not, you may not be entitled to much protection. So I would think about, again, not business advice, but consider your time to bring your product or service to the market and discuss perhaps with your SBDC counselor or your economic development counselor from a timeline standpoint. When is the best time to file that notice of intent? Is it 3 months? Is it 6 months? Is it 9 months? Are you filing it so that you can conduct that further research to see if there's already a federal registration out there that for a similar product or service, you're not creating that likelihood of confusion? So, again, from a business standpoint, consider, how soon after that notice of intent you'll be bringing your selling essentially your goods or service.
Great answer. That makes sense to me. And everybody, thank you. Marilyn, thank you. That was super helpful. I use the information quite a bit. I just had an emailer, just like two sentences. How does intellectual property protection work online? So with your answers, I will be able to answer more. I just had them. I just sent a message to them to say, why don't you call me? Why don't you set up a meeting and let's
Awesome.
discuss that. So this will be super helpful. I appreciate the time. Again, I hope the interim status goes away and you are appointed.
I appreciate that, Mark. And the good thing, even if it doesn't, we know how these things go. As long as I'm
Yeah,
here, I am here to help. So anyone reaching out to Midwest or Maryland.nash@uspto.gov, I'm going to help in whatever capacity I'm here in.
fantastic. Thank you very much.
Awesome. You're welcome. Well, enjoy the rest of your day and thank you for joining me today.
All right. Thank you,
Okay.
Marilyn.
Take
I
care. Bye
appreciate it.
bye.
Everybody, thank you. We are at 3:01. We will not be doing a meeting next month. We will be here in December. Thanks for joining us. Just want to let you know, quick reminder, see if I can do this super quick. Probably not. If I get to the right screen. Nope, I'll just let it go. Just a quick reminder, everybody who's here, I'm just going to mention um, paid leave starts. The first wage detail reports, I believe, started earlier this month. Just want to keep reminding people about that. Thanks for joining us. We will see you back here in December. We will send out some notes. So thanks, everybody. Bye.